That broke earlier this evening. The president clearing and approving, in essence, the appointment of the judges. Initially 41 judges as of August 2019, 2 years ago, by the Judicial Service Commission. And there has been a stalemate and a standoff over their appointment. One judge has since died, or one of the nominees, and now you have 6 of them being referred back to the JSC, and 34 have been appointed. So joining me in studio for that conversation and much more off of the speech by the president again on Madaraka Day. He came guns blazing for the judiciary in a hard-hitting speech. So part of our conversation as well this evening. And I have with me in studio next to me is the leader of minority in the National Assembly. He's also the ODM National Chairman, John Mbadi. Alice Wahome is the Kandara Member of Parliament. We also have Maoka Maore. For the first time, you're making a debut for you, sir, the Gembe North Member of Parliament on Crossfire. You've not been with us before.
Yes.
Karibu sana.
Thank you.
And thank you all for making time for being with us tonight. So I suppose just the news coming out, as I mentioned, it's been 2 years and a lot has been said around appoint the judges. The role of the president is ceremonial. There was a court order that he issued. Maraga had that press conference, the former CJ, and then boom, today 36 in, 6 rejected. I'll begin with you, Honorable Maoka. Your thoughts on the developments today?
I think it is a step forward in the sense that out of the 40 judges, 34 got the appointment. And also the issue of where there is this discourse, whether the president had the power to cherry pick the nominees after they have been forwarded to him by the JSC, you can very clearly see once the JSC has forwarded the names, the president had reservations. From what you heard from the vice chair of JSC,
former vice chair,
the former vice chair, the issue was when the reservations or the red flag was raised on some of them, and the others have been added today. She didn't say which ones. I think we have the issue of whereby it's a major step forward.
But you've just flagged an issue, that the initial list, as had been given to them, had some names.
Yes.
The list that has come out today is different. So if there are issues then, at what point did some people get dropped, if that was the case, or other people added to the list? Isn't that curious for you, sir?
Well, I only, because actually even the lady didn't tell us which ones. I only know how many there were. She should have said whether it's 2 or 3 or 1.
But it's still an issue, isn't it a red flag that there was that change?
Well, I think what I would think myself is this is a step forward. You can see the hostility that was there with the previous Chief Justice.
Yes.
When he wanted something raised, he would go and call a press conference from the staircase of the Supreme Court. And this time, you have now the magic kind of, you can say, diplomacy with the new approach.
All right.
And 34 out of 40, so we can debate about the other 6.
All right. From where you sit, Honorable Alice Wahome, because there's still the issue of the court order. And I suppose the president is then exercising what he was challenging the nation to have a conversation about, that when it comes to judiciary, there should be a balance. So do you see it as that balance happening that with a new head of the judiciary?
First, I have taken the opportunity. I would like to just repeat that I congratulate the Honorable Lady Justice Martha Koome for this not mean achievement, a major step even for women. And I really am wishing her the best. She has come in at a time that is going to be very difficult, because transition and succession are not very good times. It is disaster and a blow to the independence of the judiciary for the president to imagine that he can cherry pick from a list of judges that has been forwarded to him through a constitutional legal process by the Judicial Service Commission. And it has become a practice by the president, with the greatest respect to him, it has become a practice by him to continuously ignore, disobey court orders, and basically just practice impunity. you really wonder if that is happening at that level, what is the ordinary Kenyan supposed to do when a court order is served on them? And therefore, I feel sad that we even have to discuss the conduct of the president, because definitely here there is some conduct that we are saying, is it correct, is it legal for him to do that?
But in public interests, as Honorable Mauro was raising, that backlog and people seeking justice,
in the first
do you see
place,
the balance?
In the first, there's no balance. In the first place, the minute you give a blow to the independence of the judiciary, whatever else you want to do, then the balance is lost. It's not in his place to choose, because it's very, the Constitution itself, the provisions of Article 172 says that it is the JSC that shall process and then recommend the names to the president for appointment. Simple. There is no place there, and we all understand.
Yes.
And so there should never be an argument that these names are not okay, because he must have lost the opportunity to, say, change here and there, considering that the president actually has persons he can be able to talk to during the process. And there is nothing wrong in conversing during the process of interview, because you can also forward information from his office, from agencies which work actually directly under the executive. And even when they were asked, because if you remember Maraga, the Honorable retired Justice, Chief Justice, he said that he requested further information on those few that there are reservations about, and he was not given. So to that extent, then the door is closed for the president to do what he did. You know what, Sophia, I want to finish by saying, actually the president is exposing the country for a legal suit by the judges. Yeah. All
right. Honorable Mbadi, I wonder where you sit on that one, because it is true that the president has a voice and representation within the commission. He'd have directly through them raised those issues during vetting.
I don't think Attorney General represents the president. Attorney General is in the Judicial Service Commission because the people of Kenya decided to put him there. So I think we need to be very clear on that, because then when we make it appear...
the people of Kenya didn't vote for him.
When we make it appear... No, the people of Kenya passed a constitution
to have an Attorney General.
Which placed the Attorney General there. He's not a representative of the president. I think that's a mistake that we keep on making. We should not make Attorney General the representative of the president in the Judicial Service Commission. Judicial Service Commission is supposed to be an independent institution, independent organ that does a very critical function. The role of nominating judges, interviewing and nominating judges, is exclusively given to the Judicial Service Commission. The president has no role. But I want to put it this way, that to me, I want to agree that appointing the 34 is a positive step. Sophia, we will sit here and say a lot of legalities and constitutionality, etc. But we must also be alive to the fact that there was a problem in the judiciary. The problem we had in the judiciary needed some solution. We only have 8 judges of the Court of Appeal, and we require about 30. Now, there is already a problem with having those 8 judges. There is a backlog in our judicial system. So I want to say, in a nutshell, that in summary, that at least there is a step in that out of the 40, 34 have been appointed. What now we need to push, in my view, is to ask for the 6 who have not been appointed to be appointed. I know the president has explained himself and has said that in terms of integrity, in terms of recognizing integrity, of maintaining the integrity of the judiciary, that he could not make certain appointments. We need to debate that and ask ourselves, yes, the Constitution places on the responsibility of every state officer to respect the Constitution. And part of that Constitution is Chapter 6 of the Constitution. But then how do you marry that to the role that is given to the Judicial Service Commission. And that is a question that Kenyans are asking, and they validly ask that question. So, to summarize it, I want to say that, yes, there is a step in the right direction. 34 have been appointed. What we need to start debating now, instead of Ali saying it is a sad day and using all such words, it has been 2 years.
Yeah, but why would you expect that he then appoint the 6? He has refused.
By the way, let me tell you.
He has refused to appoint for 6
years. By the way,
years.
let me tell you, even as John Badi, and that is why if you look at the presentation of ODM to the BBI task force, we had a recommendation on how to resolve a situation where the president refuses to appoint. Because the people of Kenya passed a constitution and did not envisage a situation where the president would say, I have reasons to not appoint.
But we don't have the framework.
We don't have that framework. So we needed to sort out that framework. But that is not to give the president an excuse. By the way, let me tell you something. So the president is wrong on this one. Let me say something here. If you ask me, the judges that have been left out, the 6, at least one I have an issue. I have evidence, although I will not put it on the air.
Which one do you have an issue without saying the issue?
I will not even say the name. Because I have issues of integrity. I know that the integrity questions around him is valid if they were raised. There is also one who has been appointed. And I also have integrity issues. So the question we need to be asking, if Judicial Service Commission has processed and people have integrity questions around these judges, what should we do? What should the president do?
And as I go to Honorable Maore, one of the things you talk about the Attorney General not being there representing the president, his chief government advisor, the government is led by the president, so wouldn't that follow that on such an important issue that he would, and I'll come back to you.
No, I would have answered that.
Okay,
I think what happens, we need to get actually the background of our debate from the president's speech on Tuesday when in Kisumu. For about 7 times, he referred to the spirit and the letter of the law. If you know the people who have ever done 101 law, you start with some philosophy. There is a fellow called Baron Montesquieu, 1748. Now, he's a French philosopher who went and dissected the issue of the separation of powers, the legislature, the executive, and the judiciary. And the issue that we need to face, the role of the presidency in that arrangement, whereby the presidency is the confluence on which other institutions of state revolve. Being the confluence, when he comes and says that the issue of the spirit of the law not in concurrent with the letter, if you are doing the work of the bench, the number one issue to worry about, yes, the letter of the law is there, how you should apply it, how it should go. But also there is the spirit. What is the intention?
And have we not had such instances? For instance, in the judgment on the CASs being not in office legally and CSs, but even in that judgment, the judge is giving time, because if you just say leave or it's unconstitutional, then it would create a situation. But even for then, you could see then there was a realization it should not then happen immediately. So there have been such instances. The concern here is if the president is the one to determine the spirit needs to apply and when the spirit applies.
It is not about the spirit of applying. What I'm explaining is the letter. You may say that there is some illegality, but practically, you are the president, you want to have an administration, you want to have it being effective, and you find that along the way, you need an officer who needs to be in this office in order for the administration to function efficiently. So I don't know what...
Some of those judges on that list that has been returned to the JSC, Odunga and Guge, were on the BBI Stop Reggae ruling. I wonder what you
see from a very casual look of the fact that 2 of them were in the High Court case, the BBI High Court case. We obviously said the wrong signals, and the president is likely again now to be accused to have maybe taken a revisit or a punishment of the 2 judges. And he ought to have been very careful and cautious about that. You see, the president is taking a burden that is not his. The JSC is the vetting body under our constitution. And however much Honorable Badi wants to say that the Attorney General is not a representative of the President, he's the Chief Legal Advisor of the President, and he would have an opportunity, since he's sitting in the JSC, to look at those materials. You know, they are not machines. They have to interrogate what information comes before them for purposes of vetting. And in fact, it is a public exercise, so that any other person with some information that is relevant and would affect their acceptance as judges, then have the opportunity to take that material. Then there's also the 2 members that are appointed by the president, the members of the public, and are also actually appointed by the president. What I'm saying, those are people who can take those concerns maybe in a more independent manner. The JSC is supposed to, yes, to be independent, I agree. The judiciary is supposed to be independent. But the minute we allow the president to be the determining person as to which judge cannot sit and who can sit and who cannot sit, then we are running into very serious problems. And I don't understand where this need for honorable members to kind of defend bad actions. You know, we've got to call a spade a spade. If there are bad actions on me or by any other person, I think we need to call them what they are and to call out and hold even our president accountable, because really he has taken the oath. And it is true, we can sit here and not have a solution, but it is not a solution to say, look, the president has refused to appoint them, so what can we now do? I know there is a court order following that refusal and saying, look, there is no way, you don't have room to do that. And the choice, the decision has been made by others who have discharged that duty. The JSC are functus official. They cannot revise their decision. And I imagine the counter-argument on that court order would be that the matter is under appeal, and then implementing the same would then undo the appeal. Sophia, whichever way you look at it, it is a dead end for this particular provision. You know, it says the JSC will do the work and then forward to the president, and then he will have the names gazetted, and then they will be sworn in. There is no place for that action. But he asked, what should we then do if then they are appointed and they have these queries or integrity issues? The same constitution provides the procedure to, if I may use the term that we use in Parliament, to impeach. There is a procedure to remove judges within the constitution itself. So if they can be appointed today, but you can still take them through the tribunal. The JSC and the tribunal. The JSC will receive the petition and then forward it if they find that the information is really relevant. And you can argue, at the time they were being appointed, even the president had withheld their names because of those issues, or the information has come to you after they have been. Some of them were being promoted from one court to another. Others were new appointees. So Honorable Mbadi, I wonder whether for you it's curious, and I want to move this conversation forward in the next stage, but curious that according to the former JSC vice chair, that those names changed. The concerns they'd raised earlier about some of the nominees, you now have different ones. Are a mix. I don't want to respond to that former vice chair, because I think he has not done any. She has not done any justice. She sat in the. She has not done any justice. She sat in the committee. You cannot go there, stand on national TV and tell us there are some names added without mentioning them. So the same way you've refused to mention, with due respect, sir, you have also not told us. The reason why I have refused to mention is I was going to touch on the integrity. With her, she has the list. She did the but also, she was, at the point she was doing that, that information was sent to them as JSC. I don't want to comment on ghost names that the former vice chair has talked about. I want us to focus on the larger debate on the action of the president. And I want to, first of all, agree with
Alice, that as members of parliament, if the president makes a mistake, we should fault it. And how this is actually what we have been doing from 2013, Alice, and you realized it late, just about 2018, 2019. So we actually need to be faulting the president or any other public or state officer for any action.
Myself.
Now, regarding where I want to really persuade us is we should not treat Attorney General as a representative of the President in the Judicial Service Commission, because then it means before the AG goes to the Judicial Service Commission to interview judges, he should take briefs from the President. Is that what we are saying? That the President should advise him on how to go and conduct the interview. That would be interference with the work of Judicial Service Commission. Our Attorney General is sitting in the Judicial Service Commission as a commissioner put there by the people of Kenya through the Constitution.
Isn't he already interfering?
Interfering with what?
The JSC did their work. He was supposed to appoint.
But that is,
you see, Sophia,
but you are saying she's interfering with this, and we should allow him to interfere.
But Buddy, this is a process of vetting.
Can I just?
You understand?
I think you are not. You are not even understanding what I'm saying.
Proceed.
So just calm down, and when I finish, you take up. What I'm saying is we should not ask Attorney General to be representing the President in the Judicial Service Commission. That is my point.
Okay.
The other thing that I wanted also to say is that these appointments, which have not been made, the 6 appointments, we should ask the President to make the 6 appointments.
But he was asked for 2 years. So what do you think this asking will change?
Now, I don't know, Sophia, where exactly you want my argument to go.
Now, that's a valid question.
Because it appears you have a fixed direction you want me to take.
I have asked.
What I'm saying, the 2 years was not good for us as a country.
Okay.
We have talked about it. We have told the President, you have 41 names. One died just the other day. Appoint them. The 40 remaining, appoint. The President has not appointed them. We cannot go and hold a gun on his head. And the President has given reasons. What we need to be asking the President, are these reasons genuine and valid? Now, the President has made 34 appointments. The remaining 6, we should ask the President to make those appointments.
May I ask a question?
Yes.
The point I'm making is public outcry, the CJ former himself kept pushing full appointment of judges. He has had his way in not nominating those he felt had issues, not appointing those he felt he had issues. So I'm asking, and you're a member of parliament, at this point, as you say, we shall ask him, what is this thing, in your view, that will convince him, having felt they have issues, having returned their names to the JSC, to appoint them?
Okay, so then let me say, then we should not ask him, because that is what you want. So we should not ask the President, but I think that the 6 should have been appointed. They probably have issues, integrity issues around them. But as a country, we now need to deal with this problem. How then should the President of the Republic of Kenya behave when he's confronted with a list of judges proposed or nominated by JSC, and he feels, or she feels as the President, that according to, that some of them have integrity questions.
Yes.
Then the President also has an obligation to respect and obey the Constitution, which talks about integrity of people being placed in public offices. How should we deal with that? The people of Kenya need to address that issue. But at the moment, I don't think the President had much space to leave anybody outside, even if that person is confirmed to have integrity questions. And yet, the Constitution has no provision allowing him to do cherry picking, as you call it. But as it is, how then do we deal with it? So I was suggesting that we should continue asking the President. We have asked him for 2 years. We should continue, but you have advised me that that is not necessary. And
maybe let me keep it, I'm putting it into context in this way, Honorable Mbadi, as I bring it to you, Honorable Maore, because when we interviewed the CJ Emeritus Maraga, in his view, to the extent of the numerous court orders that had been disregarded, he thought that the head of state was candidate for impeachment. So that you, as a legislator, if you're going to tell ordinary Kenyans, let's just keep asking, and you're saying on one hand, this thing is illegal, it should not have happened, but on the other hand, let's ask. So at what point, and I'll begin because you had some time.
But you know the problem we are facing,
The point is, when these things happen, and there are no real, even for whatever other public official.
You're asking that question to a wrong person. Because it doesn't believe.
But you have asked the question, you have refused and said, I do not want you to speak. But the bottom line is, can we keep saying without any real consequence? We'll come back to you. You will speak to it.
No, what we need to deal with here is, if the president feels that these issues are integrity issues, he should not also allow them to go back and continue with the bad integrity issues they have. We need a tribunal to remove them from the from the bench. The reason being, if you remember when we are debating about what the president ought to do or ought not to do, the constitutional amendment of 2010, it was trying to address the behavior previously, before 2010, where the president used to appoint all the judges, and there was an issue whereby there was no criteria that was being followed. So the anger that was there in passing the 2010 constitution is the one causing this confusion, because you need to address, if you feel that the president has the power to appoint, as the JSC, you have done your work, you want him to appoint, it is very unfair to also not go into the background of the same Chief Justice.
So let me ask
you
this
he has an advisory asking for parliament to be dissolved. He is asking the same parliament, just like the president of the Law Society of Kenya, stating that they want parliament to work. Which parliament?
But the thing is, Honorable Maure, you make a good point that yes, the Judicial Service Commission should then invest, a tribunal should be set up. However, that same tribunal would require information. It's the JSC that would recommend the formation of a tribunal. The same JSC the president declined to give those reasons to. So how then would this tribunal be formed if the same JSC is unconvinced because they've not been given information?
I'm saying now the JSC should now come up and say in a rebuttal and say, we forwarded the 40 names, you had no business of not appointing all of them. But now that you have a problem, tell us what it is you have.
They already asked for the reasons.
You know, the Honorable Maoka Maure is a very senior registrator, and he understands very well that it is not possible. It's just like a judge. When they write a judgment, they have made a decision. It is not possible, and even an appeal would not lie with them unless you are being asked to review. There is no provision within our constitution, because this is not even a legal process alone, for the JSC to look at those issues again. And I'm surprised also that Honorable Bandi is saying that the president, by discussing or asking the Attorney General to raise issues that he may have at the JSC during vetting, would amount to interference. Oh no, because in fact they call the public to present information. They have been arguing the president is also an ordinary, is also a citizen. So, but including the institution of the executive, there are institutions that have that mandate to look at the conduct, the background checks. Those things are normally done. Even in our parliament vetting, the background checks.
And KRA brings reports. Allow me,
so I
lady and gentlemen, allow me.
It is really
allow me to, I'll allow you to.
But Sophia, let me just say this.
Because I want us to move forward.
The president interacted with the list of judges when they were brought to him after nomination. So how then do you expect the president to send the Attorney General to the interviews where hundreds and thousands of judges are being interviewed to ask for integrity issues? So when the list is presented to the president for appointment is when the president does background check around this.
But there is a short list.
What was it?
There is a list.
List?
There is a list of those who have applied.
So you want the president of the Republic of Kenya to start picking lists all over across the country for interview?
No, not across the country.
No, let's be realistic.
There is before the JSC.
The president can only act on what is on his table.
Then
we don't expect our president to be moving around and asking who is doing interview where, so that the investigation is done around them. That I don't understand.
To your point, the question would be then, when JSC may be seeking to resolve the issue, ask for the information, because it would be the same as to recommend a tribunal.
Let us not also treat JSC as if they are as clean as... We also have issues with JSC.
All right, let's move the conversation
we are
forward.
putting JSC like there are some kind
That's
of...
the same with people, MPs.
Everywhere. They have issues with MPs, we have issues with the president, we have issues with judiciary.
I want us to play a sound, but to move this conversation forward from the Madaraka Day speech, and we was talking about the president when he was in Kisumu, had a clear message. Let's take a listen and continue our discussion.
Election in 2017 to an attempt to stop the will of the people as expressed through the BBI. The judiciary has indeed tested our constitutional limits.
Indeed, the president talking about the judiciary testing our constitutional limit. Honorable Mbadi, I wonder if you agree with that sentiment, because at some point he gave the example of the 2017 presidential election nullification and went on ahead to talk about its implications at the time. Did you agree with that sentiment by the president?
If there is anywhere where now I agree with the president is on this one, and I want to explain. You see, immediately after the 5 High Court judges made a ruling on 13th of May, there has been a conversation. In fact, immediately it sparked a national conversation and a national debate. The legal minds have engaged on this matter. There are people who have said that this issue is not even appealable, that the decision of 5-judge bench cannot be contested. And Kenyans have been debating. Now, the President of the Republic of Kenya has a responsibility and a duty to speak to the people. And you don't expect the president to call a press conference and start addressing issues of BBI and the issues of the judiciary making decisions here and there. The president must also get an opportune moment to speak to the people of Kenya. And the Madaraka Day is a national event. First, remember that the BBI that he was addressing, I just want to confine myself to the BBI first. The BBI issue, for the BBI judgment that he was talking about, remember BBI was passed in 43 out of 47 counties. Remember, VBI was passed by 234 members of the National Assembly and 51 senators. Now, these Kenyans have expect from their president to speak to this matter. The president has invited the country to a national conversation about not only the independence of the judiciary, but also whether we are not witnessing judicial dictatorship.
May I ask?
Because let me tell you, Sophia, a dictatorship by executive is very bad. Dictatorship by legislature is very bad. And dictatorship by judiciary is very bad.
But Honorable Mbadi, in 2017, when the election was annulled by the Supreme Court of Kenya, you were jubilant, you celebrated. So how is it because today you are supportive of BBI, may I finish? Supportive of BBI, now the same judiciary is being...
Can I tell you something, Sophia?
Yeah.
The fact that I celebrated the decision in 2017 does not take away the rights of Uhuru Kenyatta to invite the country and the public to debate.
So do you agree then with the
President
point he
Uhuru Kenyatta invited Kenyans. I may not agree with everything that he said. I'm not Uhuru Kenyatta, and I'm someone who can independently think. Uhuru Kenyatta has his own thinking, and he cannot think the same way John Mbadi thinks. But what I agree with is the fact that he invited Kenyans into a national conversation. And this conversation must proceed, and that is what we are doing here today.
So part of the national conversation he was inviting us to, and perhaps briefly as I come to you, Honorable Maore, is that the annulment cost the country heavily. That $1 billion was being lost every working hour. So in hindsight, would you agree with that position, that perhaps the judiciary was irresponsible in so doing and not putting in picture
what I advise you not to take me to is to agree with everything that Uhuru Kenyatta said. What I am saying, and please don't, I know where you are taking me. I have told you, and by the way, I'm intelligent enough to understand you.
It means you're
the
running
truth
away
is
from
this,
my
I'm not
question.
running away from anything.
Yes.
What I'm saying is that Uhuru Kenyatta, as the President of the Republic of Kenya, has a duty to invite this country to a national conversation.
Okay.
He has a right to express himself, including the petition, the presidential election petition, including the decision by judges on BBI, and including even the numerous court orders that have been flashed by the judiciary.
Yeah.
You will ask Alice Wahome here, he agreed with the president on the issue of She agreed with the president.
Just in case people...
Yes, Alice Wahome is definitely a lady, so it is a she.
Yeah.
Alice Wahome actually agreed with the president entirely and completely after the Supreme Court decision that was wrong.
Okay.
I completely agree with the president now.
And which is a case of
BBI is wrong.
Which is a case of politicians shifting position based on what suits
We
them
are
in
human.
any given
No, it is not
moment.
shifting.
No.
It is not shifting.
If you have a reason to shift your position, there is no problem.
All right.
No,
good
no,
point.
it is not shifting. If you remember that ruling on the 1st of September 2017, it was one of the most rare
It was
kind of
historical,
rulings,
yeah.
whereby you have the millions of people voting, and then the judges come and they don't take care into the consequences of even their conduct. Care in the sense, even after nullification, there is nothing they corrected. Because even the person who had sought the nullification didn't participate in the next election, in the repeat. Because he said, oh, the issues of IBC are the ones that have made them complain, and it has been confirmed there were irregularities. But then they didn't participate. If they had participated, then there would have been a very justified kind of ruling that time.
Yeah.
Now, come to the BBI.
Yes.
It is another subversion of the will of the people. The people who, because surely if you have a problem with the BBI, you don't go and beat about the bush. Just go to the referendum, go and vote against it. And then it will be stopped at the gate.
But the court halted it. It's under appeal now, so let's not go into that. But the
Yes.
question I'll put to you, during his speech, the president, in canvassing the matter of BBI directly, is currently a party in that matter, live in court.
Yes.
So isn't that sub judice being out of order as far as speaking to a matter that he is a party to directly as president?
No, speaking to a matter that is before court, any lawyer like Honorable Alice will tell you, is when you're talking the merits or the merits. He commented about the ruling. Commenting doesn't mean you have said it was right or it was wrong.
He said that is the will of the people.
Yes, that's what I'm saying. Even me, I'm repeating, it's the will of the people. It's actually, it came out of the will of the people.
Okay.
Yeah.
I wonder what you think of that.
Oh, he may not have talked about directly about the merits and demerits of the appeal,
Yes.
but he sent messages, very clear messages to the judiciary that they were wrong in 2017 and even in this time
BBI.
when in the BBI ruling, and that they are not thinking about costs. So he is trying to ask them to subvert justice in lieu of costs. I think that is very simple, because he's saying, is the judiciary ready to bear the costs? The judiciary is not supposed to bear the cost. The cost would be borne by the country or by the litigants. In a constitutional matter, actually the courts don't necessarily award even costs. Of course, they are the huge costs.
But was he talking about
maybe
cost?
they were talking about the main cost of the BBI process. You know, there was a lot of whatever.
Wasn't it more the cost of the burden in as far as the implication, how it ravages the economy?
One of the burdens, I think, of course, he was talking about is that the time we have spent, the resources, the energies that the BBI people have talked about, have spent, and of course, even those who have been opposing, we've also have spent a lot of time and energy. So he is saying the court should think about that, irrespective of whether this process is justifiable, is correctly done, and I think that is not the way to go when you are talking about changing the constitution of a country.
And yet he actually said of you who have opposed BBI that you're not really opposed to it.
You know now,
you don't disagree entirely.
I think those are frustrations, Sophia. You know, there has been a deliberate effort to use force, arbitrary conduct, including the police, and therefore it's like the president is saying, I mean, you cannot say the litigants who are in court seriously. Let's even forget about the politicians who could have a different agenda. They are litigants in court, and they need their fair day, even on the appeal.
Yeah.
I think it was totally out of order. You know, even the Chief Justice is new. She was present. And this message by the president about you people, you are not thinking about the cost.
Okay.
You know, really, I think it's very bad. It's very bad.
If you took your time to listen to the president's speech in its entirety, the cause that the president was referring to was not the simplistic cause of what has
violence.
It was
the
a combination of the bigger picture. Looking at, first, he even asked, now how are we going to sort out the issue of the majoritarian kind of governance that we have? How are we going to sort out the issues that when he was actually telling the judiciary that when we shook hands with my fiercest competitor, Raila Amolo Odinga, in 2018, March, this country was at crossroads. That there are things that we agreed we would sort out so that they are not repeated. Now, if you are stopping us or blocking us from doing it, who is going to bear those costs in future? I think that is what he meant. But let me explain something, Sophia. If we are going to stop the President of the Republic of Kenya from conversing with the people of Kenya, from talking to the people of Kenya and inviting them to a national discussion, then I think that is dictatorship by the citizens. Let me also again put something across very clearly. Judicial dictatorship should also not be allowed.
So who decides?
And I want to be very clear here. The executive dictatorship, the executive has a responsibility to implement programs and policies. We should not interfere with that unless they go off the rail. Legislature must be allowed to legislate and oversight. Judiciary must be allowed to do their work of interpretation of the law and dispensing justice. Now, if Parliament, and that's why you find in Parliament we have standing orders, if you bring a petition, there must be a conclusion at the end that the matter is not active in court. But again, the people of Kenya have the sovereign power. The judiciary must also be very careful, should never ever be seen to be interfering with the sovereign power of the people, because that would be judicial dictatorship, which is as bad as legislative dictatorship or executive dictatorship.
When you say dictatorship, when there is still due process which you are canvassing at the Court of Appeal and can go even to the Supreme Court, isn't that a harsh indictment? That
is what I'm saying, that judiciary, and I'm talking about judiciary in totality. I am not singling out a particular court, a particular judge. I'm talking about judiciary. Judiciary, and that is why, in fact, it is a common practice that political processes should never be interfered with by the judiciary. Judiciary should try as much as possible to let political process move on and should not even interfere with the legislative work.
When you say political process, like very heavily, hotly contested elections we have, and it's our laws because we as Kenyans agreed, let them come and help adjudicate when the politicians don't agree.
I want to tell you something.
Yes.
I would not like to see where judiciary decides on how votes should be counted in the polling station. There should be a point of intervention.
Dispute resolution?
But that is why we are saying this matter needs discussion. I'm not saying I have the answers. But the question is, at what point, when now judiciary starts telling Wanjiku, who gave themselves the constitution, on how to start a process of amending the constitution, there is a problem.
All right.
There is a problem. Because, no, let me just finish this. there is a problem. If you are telling us, judiciary, that we now need to hire lawyers and pay them to help us know how to start the process of amending the constitution through popular initiative, there is a problem. The people of Kenya gave themselves a constitution where we could even just go to the Uhuru Park or Jivanji Garden, sit there and agree that there are provisions in the constitution which we don't like.
Okay.
Go and collect 1 million signatures, and we ask the people of Kenya to agree with us or not. Right. In fact, in the constitution, it's even said people of Kenya can put those suggestions in form of general suggestions. We don't even have to produce.
And you maintain it was the people, and the judges in their ruling maintained it was not the people.
That is the problem we have. If it was not the people,
president's initiative.
If it was not the people, and Sophia, please be
That's what
balanced.
The judges say.
Be balanced in this. Be neutral.
The judges
say
listen.
First,
neutral
if
is
it is not, if it is not the people, no. But and again, being neutral does not mean you always disagree with me.
I am pushing back for you to make your point.
Just listen to me, Sophia. You know, I debate. The point is,
that's why this is crossfire.
If it was not the people of Kenya, if it is not their intention,
they'll drop
if the 4 million people were wrong,
correct,
they would defeat it at the referendum.
Fair enough.
It is not the work of 5 individuals in this country, whether you are as seniors who
you have now made a very good point, emphatically, because of that question.
Sophia, don't try to please me. Let's just go on.
Honorable Maore, the president in his speech says, I'm a believer in the rule of law, and I will continue respecting and obeying court decisions. And we know that on record, that has not been the case even in the recent past with KMC. So how also does the judiciary, in being put in this position to be aware and conduct their affairs and run their mandate in awareness of the country, in essence, they live in, that they're not foreigners in Jerusalem, how do they then reconcile that the president also is not respecting the court? I
am glad actually you mentioned that case of KMC, because he went into serious discourse on it. And they said during the Kibaki administration, after KMC had collapsed for 16 years, they pumped money. And they were just painting, and then the rest of the money was taken away. Then even in his own administration, they also pumped money, painting, and nothing happened. But now when something is happening, is when somebody rushes and just does now a court ruling that this is an illegal entity. So surely what pleases you and me as a Kenyan? Do you want something functional, or you want to actually litigate on a dysfunctional behavior of how we have rotten institutions? There hasn't been, in the last 30 years, anybody who has moved that KMC as efficiently as a few days when the military has been having it.
Will that be a slippery slope, that there are moments when the president, convinced that he is going with the will of the people, then act out of that? Because then who decides? Well, if there isn't that oversight, there's parliament from you, there's the judiciary.
No, I think
not oversight from the
that is exactly what Honorable Badi was trying to explain.
Yeah.
If, for example, parliament is in the process of passing a bill, you cannot intercept the process of passing a bill. You wait for the bill to be passed, then the court can interpret.
So if the president is doing something? No,
the president has decided that the best thing to do is to give this administratively to the army. The army they are not from another planet. They are a part of us. So I don't know what is the problem with the army running it. Whoever was talking about the litigation, I don't know what was irritating. Maybe a lot of Kenyans don't want things to work efficiently.
Okay. Honorable Wahome, I wonder whether you think now, with the spotlight turning, with that challenge that was posed by the president on the judiciary, how the CJ will navigate this tightrope?
First and foremost, I don't think, I am hoping that the Honorable Chief Justice did not negotiate for some judges to be appointed and some to be left out, because that would not be different from what the president has done. So I would just hope that that is not the case. Secondly, I think it is important for the country to have now the entire list that was taken to the president, because of the statements that the former vice chair has made. We need full disclosure of the list.
The entire list is public.
So that now we can see which names may have been put in that were not there. I have seen the names that were left out, and I've also seen the names that have been gazetted. Then secondly, I am saying that the spotlight on the president is definitely, was definitely meant to overweigh, to kind of, in a way, influence, exert some pressure on the judges so that they can know some sectors are not happy, including the president. I mean, it was clear that it was not a message of goodwill or best of luck. We are hoping that and he said, yes, he will agree with the decisions, but then when you agree with the decision and then say you agree with the decision, then the statements that you make speak to the point like you are lecturing, like you are castigating the judiciary in front of its head, is definitely not, I don't think it went well with even the litigants. And they raised it. The first thing they did was to raise that issue.
And even the judge gave
and even the judge also alluded to that issue. And I hope that they can be able to, because they now need to recreate confidence in those people who are litigating before the court, and even in, among Kenyans, because of those statements. I think the president has created another fodder for suspicion, another fodder for an attack on his own whatever. But I think there is a question you are asking them about KMC. Is it not another selective justice case? You know, I mean, he's selecting which orders. I think the president of the Republic of Kenya is heading a civilian government. We elected him as the head of state and government in this country, not as a military head. So, and the military has specific functions. And I don't think that when the matter has been litigated, there must have been issues, live issues that were discussed, and the court found that what had been done was wrong. And you see, Sophia, the existence of the judiciary is to check and balance out some of these things.
So then let me ask Honorable Mbadi, based on that, whether you fear, if you agree with the sentiment, that we could be heading a slippery slope if there's also cherry picking in orders, because you are aware of several that have been disregarded, but there are those when also he feels the judgment has, like on this instance, he was clear to make a case for. So do you fear there could be a risk?
Yeah, first of all, allow me to correct Alice that the president did not agree.
No, not to correct. You just make your own position. I don't think it's correcting.
Yeah, you are wrong to say that the president agreed with the judges. The president did not agree.
He said...
Just listen, I speak.
No, you know, you are now interpreting what I said.
Now, when you get your time, so you'll come back and say, Mbadi got you wrong. Can I just take my
think that
airtime?
you need
no,
the correct perspective.
I'm not going to allow you to take
let him speak. Let's hear what he'll have to say.
Alice, I wanted just to say that the president did not agree with the judgment. That is why he appealed the judgment. The president accepted. You know, accepting is different from agreeing. So he has not agreed with the judgment. So just get that. No, you used the word agreed. That's what I said. You used the word agreed.
Okay.
That I'm very keen.
Maybe
so I just wanted to
accept.
He did not. It is not the same thing. You can accept, but you don't agree with. What you accept, it has been done, but you don't agree with what was done. Now, let me answer your question. I don't believe that in this country we should disobey any court order. However frivolous that court order is, the only thing that I would want to say is that, and I want to go back to judicial dictatorship, that judiciary should be also very careful in giving orders. Because the orders you give should have the force of the law. And the orders that you give should be obeyed by everybody. Like, I want to give you an example. The judiciary comes and says that Appropriation Act of 2018 and 2019, for example, was unconstitutional and therefore should be corrected. We are in, for heaven's sake, we are in 2021. You are talking about Appropriation Act of 2018, 2019. Appropriation appropriates money and it is spent in that year, including the salary of those judges. Now, when you tell us that it is unconstitutional, illegal, and therefore you are giving an order that it should be corrected. What are you telling the country? So what I'm saying in a nutshell, by giving that example, is that judiciary, for heaven's sake, should give orders after thinking through these orders carefully. In this country, orders are dished out so liberally, too much. You find every Dick and Harry rushes to court, gets an order. And you injunct everything in this country. I don't think it is right, Sophia. Okay. But once a court order has been issued, if we want to be a civilized country, if we don't want to cause anarchy, we need to respect those orders. And I'm not going to sit here and say that the president has done is right in disobeying any court order, however frivolous it is. Whether it is for Miguna to come back, that should be respected. Whether it is for KMC, it should be respected. Any court order, including the one asking the president to appoint the 40 judges, needs to be respected.
All right.
Yes.
As we go towards the end of the show, BBI appeal hearing date has been set. It's likely, depending on how it goes, it may end up at the Supreme Court. Either way, there's now concern and talk of timelines and how those look like. Are you looking, when you hear other MPs talking about an IPPG to salvage BBI, do you support that thinking, sir?
Now, I believe the IPPG of 1997 was motivated by patriotism, was motivated by the love for the country, and also it had public interest and goodwill at that time. If you remember that time, 97, we had actually lit the streets of this country in a big way. And Moi intercepted the process by knowing that if he allowed changes to go with that kind of euphoria of that one, we would end up with an angry document like the one we got in 2010, which actually is giving us a lot of headache in implementing it. If you remember the IPPG and the characters who are now advocating for this kind of an IPPG or a parliamentary thing, they are people who have been fighting BBI for the last 3 years, from actually 2018. They have bastardized it. They have insulted those people who are involved in it. They have never participated in even any caucus.
I know the likes of Sakaja are part of it. Was he?
No, what I'm telling you, if you look at his history, he has never been very forceful about BBI, for example. You can say even Otiende Amolo and Sakaja, they are maybe strangers in that team, but the rest of it are the people who have been fighting it. So there is the story of consensus. When you hear consensus, it is from the people who have been fighting it from day one. After they have realized that this thing might go on in their absence, now they want to intercept it, and they now look like it can be sanitized. Everything should be, we wait for the court ruling, whether it goes to the Supreme Court or not. We go to the referendum. Okay. Let them go and vote no.
All right. Honorable Wahome, on that also, the IPPG route a bit.
I think what I hear them saying is that if there are some issues, because now I think there is panic that everything is lost. You hear that people are saying, are we losing everything? And if you listen to the church, the religious organizations are speaking to the fact that maybe it is time to rethink again and see whether the conversation can be restarted. But you see, there is also now this very, very clear route that the president is saying the judges should stop interfering and stopping the will of the people. While the judges are also saying we have litigants before us and they have made a case out and we have ruled in a certain way. So if you are not satisfied, then there is another court where now we are. And that court is the one that is being targeted for intimidation.
Do you then support parliamentary initiative? So I think the
parliamentary initiative is for some of those things that we can do. And they are there.
So you support it?
It hasn't come. BBI is not my thing. I have never supported BBI myself. I think the country has no time for some of those things. There is no crisis. You see, Kiereweke, these people are in the handshake. The Kiereweke and the ODM, they are in a very unholy alliance, or status or marito, some unholy union. Therefore, one being being minority and the other one being majority. And you see, one is supposed to be helping to check the government. So, you know, that kind of arrangement where they are,
but you're doing the checking
they are
now.
seeming to
the
agree.
Deputy President
no, you know,
and
it's the
yourselves
work of every member of parliament.
The Deputy President is supposed to be principal assistant to the President. He's leading a team that is opposing the President. Reconcile that for those
No, he's not opposing the President. And I don't think, Sophia, you can have any instance where the President has been opposed in terms of implementing government policies. BBI is himself, he said himself and his brother. That is not a government project. In fact, now they are saying it is a personal initiative of the President as a citizen. You know, you have seen that change. Before it was supposed to be a government project because it has also used government money, public funds, so to speak. But so therefore, Sophia, I think that if there are good things, you know, they will be brought and we test them on debate and public participation. If there are those things and they are there, like, you know, the women, the 2/3 issue, which these people have always fought and refused for it to pass, that can be brought. The question of 35, the members,
I'm the one who seconded the motion.
I think we had managed to persuade Badi. Sorry about that, Badi.
I didn't need any persuasion, by the way, on that matter.
We lobbied, Badi.
I
wanted to say that is one. Of course, there is also the issue of the tax waivers that they were promising the youth, although they are jobless.
So let's not go into the merits of the document because that's a whole conversation.
Yeah, so I'm saying there are those that even now within this BBI, within this constitutional amendment, that can be handled through Parliament and actually be maybe over
and that's
by
what the President
September.
Was saying, even you support some of that document, not entirely opposed to it.
You know, that is different from saying I support. I'm saying there are issues, Sophia,
you agree.
that that can be brought to Parliament.
All right.
I may agree with some.
Sawa.
Yeah,
fair
I may
point.
agree with some.
Fair
but,
point.
Yeah.
Honorable Mbadi,
but I don't think we should go for a referendum.
Now BBI is facing those legal headwinds. We don't know how this will end. It may go up to the Supreme Court. So the question is whether you think it would be feasible to have a referendum by August of this year, as some have kept touting the dates.
And Sophia, you should be
first of all,
time,
I just wanted to be on record that on the issue of on the issue of the 2/3 gender principle, I want to be on record that it is something that I've never asked for any persuasion. I know it is something that we need in this country. We had put it in the Constitution. We need to actualize it. And I'm doing it not just for myself. I'm doing it for my daughter. I'm doing it for my granddaughters and the other, the women of this country. But to answer your question, I don't know where Kenyans are getting this idea that referendum must be conducted before August or in August. We can conduct referendum anytime, including next year. And so, for me, we are on a process. The process we are in is that the High Court had made a decision. Now it is in the Court of Appeal. I'm happy that the timeline set is terminating early July, which means that the ruling will be made quickly. But after that, people may go to the Supreme Court. Let's wait and see. If others will go to Supreme Court and it delays, we will see up to what time. On the issue of this so-called IPPG model or concept or caucus, first you need to ask, who are these pushing this agenda? In the National Assembly, if you look at the people who are pushing the agenda, the list is curious. First, you see Aden Duale, who even voted against the BBI in Parliament and spoke certain words that are not very supportive of BBI, but not as strong as Cecil Mbarire in that list. I remember listening to Cecil Mbarire from the beginning to the end. Now that is the person you are put in the list of those MPs you want to midwife some of the good provisions in the BBI, which I never heard her speak, not even a single item, including the 2/3 gender principle, which was in the bill. She never talked about it, positively or negatively. You are now bringing Soipan. I mean, surely, are those people the ones we have among the 349 members of the National Assembly who can midwife some of the good provisions, according to them, good in quotes? Now, let me put it this way. If you want a model like that, assuming that we are now not going to a referendum, although I still believe, and I've got strong conviction that we are still going to go to a referendum. Because the people of Kenya had made a decision, whether you call it whichever route the bill came about. But the truth is that about 4 million Kenyans signed for a constitutional amendment. Now, those Kenyans should be allowed to exercise their rights. But even if, in the unlikely event that we are not going to have a referendum, if we have to come up with a system that is going to bring certain provisions in the bill which do not require a referendum to be enacted, then you need a serious engagement. You cannot get these opportunists, people who have seen an opportunity to scuttle and cause confusion, and without even involving the leadership of parliament. You know, there is a way parliament works. I just read in the papers that a few individuals, I don't know where they have come from. I think it was
just an idea they were floating.
And now, no, they have even said they have been meeting, and they have even talked of 0 drafts. I mean, surely, how do you do that? Amos Kimunya is not aware, John Badi is not aware, and I lead the minority. And you think you will head anywhere.
So
with us, you cannot. And by the way, I have made myself, and just not John Badi's position, I have communicated as the chairman of ODM. We are not supportive of that caucus, and any member of our party who is in that caucus is going against the party.
Because our time is up, I will give you the last word, because as you have highly pointed out, you may be... So, the question around this caucus and these individuals, because even you have said there are some issues you support. So, are you hijackers if you were to ever join such an initiative?
You see, Sophia,
propose?
That word would be very unfortunate if it were to be used by anybody. Even the word he's using, opportunist, it is obviously a problem that we have been having, that people think that the constitution making is it's for some individuals or for some people. Once you start talking about a constitutional process, then you have to involve and find ways of ensuring that you engage the entire country.
Wasn't there engagement
one way or the other? There was
BBI?
No meaningful engagement.
Actually,
even the police were used against those who were dissenting. And you know that it's on record. Some of this record will never be erased.
The deputy president gave his feedback at Bomas.
I think that I'm not speaking here for the deputy president. And when you invited me also, Sophia. You never told me. And I have heard, every Kenyan has heard about how, and they even agree with some of the things the deputy president said even in Bomas. And he's very clear about it. And he has really never opposed. But he raised certain issues that he felt needed to be addressed. I personally raised legal issues in terms of legal framework. I also say the process was invalid in the manner in which it was started. The process was not right from the beginning. And if you're talking about inclusivity, then you cannot call people opportunists. Then you need to say, I think we should look at it and see whether it is a good process and whether how it can capture everybody.
All right.
Actually, they are not, just 1 second. They are not opportunists, they are not even hijacking, they are actually kidnappers. They want to kidnap process.
That is a good place to wind up.
That is why the BBI reggae has stopped. Because people think they are the owners of the country.
But how are you defending those, if you're not part of the so-called kidnappers?
Because
how are you
I'm
defending them?
Kenyan in terms of constitution making. If
Who are these Kenyans?
If they are talking about making constitution,
they have not voted.
But even you are 4 million people, are not 45 million people.
Yeah, that is why we want to go to the referendum.
But
we want to go and vote.
Before you reach the referendum,
the
road is as important as the end result.
Yeah.
Let's go to the referendum and improve those.
We will have to start.
All right, we will continue.
It's a crossfire.
It is the crossfire.
We are going on.
In 30 seconds, I wanted some clarity from you that there is talk that the intention is to have the changes apply by the next general election, the changes in the constitution. Just a comment on that. Is that the case?
Well, once a constitution is amended, the provisions that are supposed to apply in the election, they will apply. Nothing will stop them.
And there are those which need timelines.
Those which need timelines, if there are those which cannot be applied in the 2022 elections, they will wait.
Okay. Yes. Because there's also
the schedule, there is normally a schedule that gives timelines of specific registrations to be done.
Yeah.
They are there in the BBI.
This is not a document. This is something that was being cooked.
But have you read it? You have not seen the schedule.
Everything.
You have not seen the schedule.
Maura, you have
Even
been
the
rather
schedule
quiet.
is not anchored in law.
You have become an
in the
observer.
Constitution.
No. I think
We need to wrap up. No, we need to wrap up. Maybe 10 seconds because...
Which schedule are you
yes, I think
talking
what we need to
about? The schedule
understand
for the
is that whether it is
I've
in
read
the
the
schedule
schedule.
or in the
Is
bill.
there?
Lady and gentlemen.
No, whether it is in the schedule or in the bill. When we pass the bill at the referendum, it has a way of addressing itself into all those timelines we are talking about.
All right.
There is already a timeline.
You know, these people
In
are
the
saying
schedule,
there are
there's a
people who
schedule
are
for
angry. These
timelines.
people are more angry
There is
now
angry for
with
what?
the reggae being stopped than those who
Let me
were
tell
angry
you,
before.
you know, let
So
me
we
tell
need
you,
to cool
you know,
down
Alice,
and have
Alice,
a good
this
and have a
temporary-
good
This temporary
conversation.
celebration may end
No,
very
but
soon.
also you celebrated.
It may end very
Why are
soon.
you unhappy when we celebrated?
not unhappy.
We also allowed you to
Continue to celebrate.
When you won on the floor of the
Continue.
House, you actually celebrated.
Continue
so
to celebrate.
Why should those people not
Continue
celebrate?
to celebrate the High Court decision, and in the event that the Court of Appeal goes our way, help us celebrate.
No
quiet.
problem. You
All
will
right.
be celebrating alone while we shall be appealing.
No, we will be
to the
very
Court
many.
of-
By
to
the way, we are
Supreme
not
Court.
alone. And by the
All
way,
right,
you are
Supreme
talking of unholy partnership. It is not your duty to decide
All
which
right.
partnerships are
I
holy and
have
unholy. You
given
are not
enough
the high
latitude.
priest.
We must wind up. Thank you
You
very
are not
much.
our bishop
Maura,
decide which
Igembe
ones are-
North Member of Parliament, Alice Wahome Kandara MP, and John Badi, the leader of minority in the National Assembly.
You know, actually, he passes as a leader of majority, including some.
And you are passing as the opposition.
Thank you.
I mean,
And thank you all
as a
for
very
watching on
strong
behalf of
member
the team that
opposition.
made
We
the
should
show
make you the
possible.
opposition weak.
It was great having your company with us. Quite a show tonight. Have a good evening.
Thank you.